بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين صلى الله عليه وسلم. This lecture is about commercial law for business students. We are going to study Section 2, Law of Agency, for the students of Al-Isra University. We are going to start on page 61. Introduction. So we have to have an introduction and definition for the agency. The law of agency is a very important part of commercial law, as companies can only carry out their daily business activities like selling, buying, trading through agents. Agents, persons actually work for and on behalf of the owner of the companies or the owners of the companies or the manager or the director. The essence of the law of agency is to ensure proper and legal dealing. So we have to have legal activities and dealings when it comes to actions carried out in a representative capacity, which is the agent himself. So he has to have a capacity for representing the owners, or the director or the manager of the company or the companies. Thus, the interest of the parties to an agency relationship, third party inclusive, is duly protected by the law. So the law is protect every dealing and activities as long as they are legally performed. What is agency? We have to know and to define agency. Agency relationship is created in a situation where one called the agent. So this person called the agent for the agency itself, working for and on behalf of the owner or the manager or the director of a company. The agent acts for and on behalf of another person called the principal. So this principal could be the owner, the manager, the director of the company. Under the authority, so the agent has to have authority, power conferred by the principal to carry out his activities and duties toward the principal on the agent, thus establishing an agency relationship. So establishing agency relationship between the agent and principal depends on the principal himself toward chosen agent. This term, agency, has been defined by the Oxford Companion Law to mean this, the definition of the agency: the relationship between one person is the agent having authority to act. So he has to have, as we mentioned before, authority to act on behalf and for the principal, the owner, the director, the manager, having authority to act and having consented. He has to agree, actually, consented to act on behalf of another person, which is the principal, in contractual relations. So they have, both of them have to abide by a contract between the agent and the principal, contractual relations with a third party. So the third party involved in this because the agent is the man in between the principal and the third party in selling and buying and dealing or performing any business activities. The term agency is also used more widely as one acting in interest of another. So if I want really to buy something, I give him the authority to represent me in selling or buying a car, a house, or anything. So it is used widely as one acting in interest of another. Theories of agency. We have 3 theories of agency to know actually what is agency means. These theories, the 3 of them, are the power liability theory, the consent theory, the 3rd qualified consent theory. We are going to study one by one and verify and shed some light to understand actually these theories. The first theory, the power liability theory. The concept of agency exists when a person, so he is the agent, acquires the power to alter the principal's legal relations with a third party in business or business activities or dealings, legally dealings or transactions, third party in such a way that it is only the principal who can sue. So the principal only can sue and be sued by the third party. So the principal, he himself, is the responsible for suing or be sued by the third party, not the agent. This focuses on the external relationship with the third party and ignores the internal relationship between the principal and the agent. So he concerned with the external relations rather than internal relationship with the agent or between the principal and the agent. Nevertheless, they are subject to fiduciary duties in the same way as agents narrowly defined. This is the first theory. The second theory is the consent theory. This arises in a situation where the agent This arises in a situation where the agent is acting on behalf and for the principal with the consent of the principal. So the principal has to agree and make this person actually represent him. Consent of the principal, thus establishing a direct relation with the two of them, duly relationship. In other words, the agent must have been invested with a degree of discretion that shows the principal has placed trust and confidence. So trust and confidence are very important in this theory actually. Trust and confidence in the agent. It is this which gives rise to a fiduciary duty. Here, both the agent and the principal can be liable for a breach of misconduct. So both of them actually are liable, not like the first theory. So both the agent and the principal can be liable for a breach or misconduct in this sense. The third theory is the qualified consent theory. This can happen in a situation where the actual authority of the principal was not given initially, but the action of the agent became acceptable and approved. So the behavior actually after the acceptance and approval were approved by the principal. If he didn't give his acceptance or approved by the principal, he cannot really act as a qualified consent person or the agent. This theory combines the consent theory with the protection of a misplaced reliance to account for actual and apparent authority. This is more clearly defined in agency by ratification. Ratification, of course, by the principal to reflect commercial reality, since authorization extended to the agent by the principal may not always be neatly contemporaneous with the initial transaction. So this has to be the two of them actually has to be contemporaneous with the initial transaction. The activity, the business activity, transactions, dealings, whatever. Agency and other relationships. We are going to talk about agency and other relationships. Agent and trustee. For certain purposes, an agent may be treated as a trustee of his principal. Trustee, so he has to be trusted from the principal toward his agent, actually, or the principal has to trust the agent in this sense or in this matter. An example of this is, an example of this in cases of money had and received on behalf of the principal. Equally, a trustee may, for certain purposes, be treated as an agent of the beneficiary, both of them. This notwithstanding, both functionaries are nonetheless distinguishable on the following grounds. So we have to distinguish between the two of them. The relationship of principal and agent is generally consensual in origin, whereas and except in manner cases a trust is created without the consent of the beneficiary or the trustee. This is the first one. The second, when an agent is appointed, this is invariably done by the principal himself, whereas in a trust situation, the trustee is never appointed by the beneficiary. The third one, the agent is for all purposes the representative of his principal in dealing with third parties, whereas the trustee is not in any way the representative of the beneficiary. Actions between the principal and the agent may be barred by lapse of time under the limitation acts, whereas no such limitation is imposed on actions between the beneficiary and the trustee. So the time is very important in this sense.